Hello and good morning to our esteemed guest, Dean Ma'am, participants and students. Welcome to the e-platform of Faculty of Law, GLS University. As is the beauty of our country, we believe that any event becomes more beautiful with the presence of God. I would like all of you to join your hands and believe in their spirituality through this e-prayer.
शुभं कुरुध्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुध्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुध्वं
It is truly said by Socrates that a judge's duty is to render justice. Rendering justice in a larger sense means giving every person his or her due. All those entrusted with power, power to govern, power to legislate, power to adjudicate, and power to punish or reward. In this context of judges, rendering justice means speedy, effective, and competent adjudication. Considering the importance of judgment writing skills, today we have gathered here for an expert lecture on the art of judgment writing by Honorable Dr. Justice Vineet Kothari, former Chief Justice High Court of Gujarat and currently designated Senior Advocate of Supreme Court of India. This lecture would followed by result declaration ceremony of the National Virtual Judgment Writing Competition 2024. Now, I would like to invite the backbone, the powerhouse of Faculty of Law, GLS University, the Dean, Dr. Mayuri Pandya, for her welcome address. Ma'am, over to you.
या देवी सर्वभूतेषु शक्तिरूपेण संस्थिता नमस्तस्यै 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 namo namo. I bow down to Vidya Shakti present in one and all who are virtually who have joined today with us on this very important day of GLS University, that is the national event of judgment writing, result declaration, and the special guest lecture of Honorable Mr. Justice Vineet Kothari sir. On behalf of Faculty of Law, on behalf of Faculty of Law, GLS University, I welcome all of you, and especially our special guest today, Honorable Mr. Justice Vineet Kothari sir, former judge of High Court of Gujarat, who accepted our invitation. All the participants across India who participated in this event, everyone, all the invitees who have joined today with us, the media, and all the students of Faculty of Law, GLS University, and all the faculty members. I welcome each and everyone on this virtual platform. I'm thankful to respected Vineet sir for accepting our invitation. Sir, first of all, I express my sincere gratitude for accepting our invitation, and to appraise all the participants across the country and all the students of GLS University of Law. Honorable Justice Vineet sir is, we can say, is a crusader. A crusader in a sense that a crusader who can beat the injustice. Is many exemplary judgments that has shown that a judge who can be the impartial against any economic, social, or political background of the both the parties. We are very much, sir, we are honored that you have accepted our invitation, and Vineet sir has his expertise in his, especially in terms of the taxation law. I feel sir, and sir is also an academician, because there are so many publications, sir, not too flattering, but there are, I think, very few judges who have these many number of publications. It shows that you have a keen interest in academics. And no words to express more. Thank you so much for accepting our invitation. I heartily welcome you on this virtual platform on behalf of Faculty of Law, GLS University.
Thank you.
We have to address the Lordship and all the participants that around the year we have many activities that we do, and we as a very responsible stakeholder of we know that every country has to meet the sustainable goals, sustainable development goals. So, in line with that, being a very responsible stakeholder, we have many different activities that we do. And as a part of that, these particular national judgment writing, last week we had the national client counseling competition, and today is the national judgment writing competition announcement. All the participants who have worked very hard, and even only the participation makes you the winner. But as a formally we need to announce, but you all are the winners for us that you have participated. And definitely you are the best of the best because your institution has selected you and you had the guts to come up and be the part of this. Because without practicing in court of law, without being an advocate, without being a judge, you write a judgment. It shows that it requires a lot of hard work. The object of this exercise from our end, from our university end, is only to make you understand that it is very difficult when you write even a one paper. Then when you write a one judgment, how difficult it is. And you know that many of the judgments runs in thousands and thousands of pages, which the judges are working so hard, and that they have to, and they can change the entire face of the whatever the problem is, or they can preserve the constitutional, all the our, whether it be the fundamental rights or the constitutional morality. So I think that this is a great exercise for any student for the judgment writing. And when we talk for judges, we always remember the Honorable Mr. Justice H.R. Khanna, and you know that he stood up and the cost that he paid, that dilemma that when he was writing the judgment of during the emergency, and rest is the history that we know that the constitutional amendment, 44th amendment of the constitution. So a judge can change the entire, the interpretation, entire, and it reaches to it's the last resort, the last hope for the common person. And so, and we are blessed that the Indian judiciary is considered to be one of the best judiciary in the world. And one of the legend is today with us, Honorable Mr. Justice Vineet. So I again welcome you without wasting much time. Over to Neha again. I welcome each and everyone who have joined today. Congratulate you and thank you so much.
Thank you, ma'am, for such a warm welcome. Formally introducing our guest for today, Honorable Dr. Justice Vineet Kothari, sir. He is a distinguished legal professional with a rich background spanning over several decades. He is also a renowned senior advocate designated by Supreme Court of India. With a comprehensive education, including qualifications in CA, CS, PhD in taxation, and LLM, Sir has established himself as an authority in various areas of law spanning from international taxation, corporate and insolvency laws, property and family laws. Notably, his expertise extends to ADR, where he actively engages in resolving commercial and contractual disputes through arbitration and mediation both domestically and internationally. With a career that has seen him serve as a High Court judge across multiple states in India, including Rajasthan, Karnataka, Madras, and Gujarat, Sir has adjudicated on a diverse range of legal matters, amassing an impressive record of deciding approximately 50,000 contested appeals and civil cases with minimal reversals from higher courts. Beyond his legal career, Dr. Kothari is actively involved in academia, having contributed to national and international conferences on topics related to taxation and judicial practices. He holds esteemed positions in organizations such as the International Association of Tax Judges and has authored papers published in prestigious legal journals around the world. Notably, his dedication to public service is evident through his leadership roles in various legal services, authorities, and mediation centers, as well as his advocacy for social causes such as education and poverty alleviation. Additionally, Sir's family background underscored a tradition of excellence with familiar ties to the legal and accounting professionals. His commitment to holistic development is also reflected in his pursuit outside of law as well. Now, I warmly welcome and invite the guest for today, Honorable Dr. Justice Vineet Kothari, to share his expertise and wisdom on the art of judgment writing with all the this platform. We welcome you, sir.
Thank you. Thank you very much, Madam Neha Dr. Mayuri Pandya Dean Faculty of Law is there. Madam Dr. Jia Matarani is there. I'm indeed very grateful and feel honored that you were kind enough to invite me to speak my thoughts on this judgment writing, art of judgment writing, on this very unique kind of event which you have very nicely conducted. And I requested the law graduation students to write even at this stage, as Dr. Mayuri rightly pointed out, the judgment, even though not being a lawyer or a judge or even advocate so far, practicing in the courts. It is like training a child how he would run a marathon later on in the life. And that is what the job of good law college and law school should be. The other day I was attending a ADR function conducted by LLU Jodhpur 2 days back, where Allen Overy law firm from world over brought 26 teams and they were doing negotiation on the table, displaying their mediation skills. So these kind of competitions, besides moot court, the formal moot courts, which in large number happens in the law schools, is a very, very good effort of the law universities and law schools to inculcate the true sense of justice and the justice delivery system to the young boys and girls who are the future professionals. And friends, I must congratulate you all because you are going to belong and you already belong to the most noblest of the professions on the earth. And I feel lucky that despite being qualified as a chartered accountant, my guru shifted me in 1984 from CA profession to legal profession. He alone knew the heights of this profession. I was a young boy, so could not really comprehend what kind of things we can render to the society being a lawyer or a judge. So I must congratulate you and thank you for being here in this webinar and this event. And of course, the results will be declared later on in the function. But I must congratulate you all for participating in this event because it's the participation, as Dean Madam rightly pointed out, which is very important. Who wins or loses is secondary, of course. Winner is, of course, to be congratulated more. But all participants need to be appreciated for their efforts. And I'm very happy to be part of this process. And let me now briefly give you the idea, because I have been on bench for 16 years plus period in 4 high courts, as pointed out in my intro. But one introduction which nobody gives on mine is that I'm ever a student of law only. And I want to continue till my last breath only as a student of law. And that is what keeps you burning and keeps your midnight oil also burning. And that is what this profession is all about. Now, as far as judgment writing is concerned, There are few tips which, out of my practical experience, I would like to give you, because you young lawyers and advocates will also have chance to become judges at different stages of your life, either as district judge or as a high court judge or even Supreme Court judge. God bless you with that. And that is what making of a good judge right at the beginning, at least learning the ropes, learning the art of judgment writing is a good thing to happen in your this period of life. And friends, to my knowledge, and I'll give you some quotations also somewhere, how a judgment should be written. Now, as you all know, judgment are two types: judgment in persona and judgment in rem. So, a judgment in persona binds the parties who are before the court and have brought their dispute or lists before the court. So the judgment, after considering the evidence on record, after hearing the arguments of the learned advocates on both the sides, should render in true sense the justice within the framework of law. Now there is a difference between the two. I'll try to explain it to you. So a judgment should be well reasoned, first of all. It should be fair. It should be unbiased. It should be transparent. It should give a flow of the facts, reasons, issues, and findings and conclusions. The judgment, ultimately, parties start reading a judgment from the backside, allowed or dismissed. So that is the final result, which may affect their case, which may affect their lives, which may affect their fate. But a judgment without reasons is like a hollow utensil, which no vegetables in it or no tea in it. So a judgment without reasons is a hollow thing. A judgment should always give reasons. Uh, the judgment writing is an art. So it should not be like you typically follow only the fill in the blanks kind of things, that these are the facts, these are the issues, these are the evidences, and this is my conclusions with reasons. Sometimes, particularly in higher court, an expression of other subjects like philosophy, the sociology, etc., which are necessary part of the life which your judgments are bound to affect in civil jurisprudence or criminal jurisprudence, both the sides. You should have a comprehension of the entire social fabric of the society so that you can really render justice in true sense with good reasons, with good fairness and good transparency. Fortunately for you, I have a book with me today. This book, Anomalies in Law and Justice, written by a former Supreme Court Judge, Justice R.V. Ravindran, and good books are always good companions, I must tell you, because for this legal profession, unless the young lawyers, students, and even professionals, even judges, do not read these kind of good books, they lose out on something. So your book should be your best companions, and you must always give your some time to the good books also. And I am very fond of the books. So in this book, in one of the chapters, Justice Ravindran deals with the art of judgment writing. I'll read some part of it so that you get a better comprehension of what I'm trying to say. He says on page 353, the object and purpose of a reasoned judgment are: number one, to inform the parties or litigants the reasons of the decision; to demonstrate fairness and correctness of the decision; three, to exclude arbitrariness and bias; and four, to ensure that justice is not only done but also seen to have been done. You must have heard of this clip many times, that justice should not only be done, it should appear to have been done. What does it mean? It means that not only the reasons and findings in your judgment are unbiased and fair, but it should also give a feeling of that you have dealt with both sides' contentions, both sides' issues in a fair and unbiased manner. That is when the judgment is also seen to have been done, should be palpably be felt to have been done. And that is what the emphasis and underlining of all this. One of the interesting extract from this chapter, which I would like to read to you, is Justice Holmes, a South African judge. He came with a very strange kind of situation. I'll read that part. In this case, he says, Justice Holmes, in this case, the applicant's affidavits were in English and his counsel addressed the court in English. The first respondent's affidavit was in Afrikaans, a different language, And the counsel for the respondent addressed the court in Afrikaans, a different language. In which language then should court give the judgment? It is assumed that the judge understood both the languages and yet the means to understand the meaning of both the languages. Fair enough. In which language then should the court give the judgment? This was the dilemma which the judge faced. And he said, one's experience is that the winner is usually content to know merely what that he has won. Writ petition allowed or case allowed, decree given or not given. But the loser likes to know the reasons why he has lost. I proceed therefore to give judgment in the language of the losers. This is very important. You may not be faced with these kind of situations all the times. But then to realize the importance, the feelings, the mindset of the loser party is very important for the judge. His judgment should give those kind of cogent reasons and fairness palpably felt in the judgment that the loser always feels also satisfied and happy that at least judgment has been done. I may not have a good case and the honorable judge has given reasons which even appeal to me. Maybe I have to take the matter further to the appellate court. Maybe that I'll agitate my issues further. But then this honorable judge or this honorable court has at least given good reasons with all fair and transparent things. This is very important for the judges to understand that it is not only their personal feelings which is important. It is the reasons given to the in the judgments while giving their findings after weighing the evidence and after hearing the arguments, which is very important, which is very integral part of the justice delivery system, a fair and reasonable hearing. Even if the judge might know that the fate of this case is going to be against the particular lawyer or particular party, still the need to give a fair opportunity of hearing is always there and he must be there. As a judge, I have felt this palpably in my court, in my experience, that even if you know the fate, the opportunity of hearing given to a particular advocate or a party is very, very important and relevant. His satisfaction that he has been heard is very, very important. That maintains the faith in the system, that maintains the faith in the courts, that maintains the faith in the institutions. Now, let me give you something from what I have. I am not self-boasting, but for my 50,000 judgments and with only 2 or 3 reversals which came my way, and that might be a view possible always, there is there because justice is 2-sided coins always. This is another thing which I want to read to you. This is one of the best mementos which I got from a very senior tax advocate in Karnataka High Court. And he wrote this beautiful few lines in poem. And that reflects what the qualities people felt in a good judge. It's not only about me. It's only about the judges who should reflect on the matters before them in so much of depth, so much of integrity, so much of honesty, and so much of transparency. And for that, I'll just tell you another instance. He says, the learned senior advocate, a tribute. The heat of the desert breeze, because I come from a desert place, Jodhpur, Rajasthan, flew into paradise of cool and freeze, Bangalore. Welcomed with sense of apprehension, but in the time he removed the tension. His passion for numbers in law made him decide with lesser flaw. His patience lead him to give unlimited time, satisfying conscience who stood the line. With sense of hope he departs, but in our hearts he will never be apart. He made us think aloud, now drifting away like summer cloud. High Court text. I think what a judge doesn't need all this, but this is what goes with you lifelong, that perhaps whatever you did was appreciated by the bar people because the bar is the judge of the judges. They only tell you whether you have been good, bad or indifferent. One should always strive to be good. One should always try to excel because this is the profession where it is said, sky's the limit. And you can, and it's also said that there is always room at the top and crowd at the bottom. So this you will find thousands and lakhs of people with black coats and black gowns. That's the crowd. For rising to the top of the tower, you have to work hard. So there is always a room at the top. There is always a place to go to the top, irrespective of any kind of competition. If you are doing hard work, you are trying to reach at the top. One more instance I want to cite before I give my few more tips to you, young brothers and sisters. in this session, and I'll not take long because long lectures or long things do not matter. It is the substance which matters, and if you pick up even few points out of that and intend to make your career in this legal profession, adopting those thoughts or at least points, I think I'm rewarded by being here. You must have definitely heard about Palkiwala, another book which I always love, and another iconic figure in this profession, which everybody has great respect. And you might have also heard that of his budget speeches, which happened on the next day of the budget announcements on 28th February. There were pin drop silences, irrespective of the number of thousands of people who attended that. Even in the stadiums, he was such a genius person. I've never had occasion to meet him, or I've never had occasion to hear him as a judge, or even appear as a lawyer with him or without him. But he is such an iconic figure. His books, his articles about him, etc. So if you happen to read some, I think you'll be really inspired and by those anecdotes. Now, this article is written by Mr. Harish Salve, another legendary lawyer now, I think almost top-ranking lawyer in the country, who lives in London but practices everywhere. He writes about Palkiwala like this, one paragraph only for your kind benefit. Mr. Palkiwala was a genius in every way. Whether he was mesmerizing 2, 3, 5 judges' strength, 9 judges or 13 judges, Keshwanand Bharati happened in 13 judges' court of the Supreme Court, or whether he was mesmerizing audience who stood in Azad Maidan hearing him speak about the budget in the pouring rain. Hearing Mr. Palkiwala, not just the approach to law, not just the skills of advocacy, I can never forget. This is what Harish Salve says. I can never forget when we had the privilege of working with him in the Minerva Mills case, 1979. Every time the judges would resist. Now, this is very important for lawyers to adopt these strategies. Every time the judges would resist, Mr. Palkiwala would drop the point of law and get back to his rhetoric, and which was mesmerizing. Palkiwala was such a wonderful orator that he would, I'll tell one more instance about that he would take the judges in court in his sweep, and they will be just mesmerized with the art of language which he used, with the art of expressions which he used, and with the kind of knowledge bank which he had, not only in tax laws, constitutional matters also. Similar is a constitutional judgment. Every time the judges would resist, Mr. Palkiwala would drop the point of law and get back to his rhetoric, which was mesmerizing. He would raise the temperature in the court, and the same law point put across went through like a knife in the butter. He would raise the rhetoric, raise the level of thought, heat in the court of thought process, not the argument, and then put the same law point which he dropped when the judges resisted, and that would go like a knife in the butter. That was Palkiwala as a lawyer. Now, these are arts of advocacy. These are traits of a great lawyers, which we lesser mortals should try to emulate. And this is where the iconic figures have to be followed, and we should try to treat their part. Coming back to the judgment writing, I have been a votary of judgments being brief. They should not be hundreds or thousand pages. They should be self-contained. They should give all reasons. They should deal with all issues and contentions. And they should disclose the mind of the judge. Because unless the mind of the judge is known, the parties will never know what was working in the mind of the judges. And that's very important. Therefore, brevity not at the cost of merit, but not length at the cost of the volumes of papers only. There should be a balance between the two. And that is what I try to maintain, not only as lawyer, but as a judge also. I have written very few out of 50,000, very few judgments which crossed the mark of 100 pages. I have dictated most of my judgments which ran into 15 to 20 pages covering everything on board, just on the conclusion of the arguments. And that is what gives so many advantages to a judge. Firstly, there is no guesswork. Secondly, you deal with the contentions because you are fresh with the matter. The lawyers know that their contentions have been dealt with, they have been recorded. The issues have been covered. If something is missed out inadvertently, they are always there to assist you. and tell you, sir, this was another point which I always also argue. You please deal with it in the manner you like. So that kind of ready assistance is not available to you if you reserve a judgment and do it after a month or 15 days or maybe more than that. That is a, with great respect to our honorable judges, and that practice should be discouraged, reserving the judgment and keeping it pending for months and years. No, I don't approve of that. None of my judgments, if I cite my own example, went beyond 10%. I had to reserve for do some more research on the work, on the issues. Did not spill over beyond a week. Whatever time I had to devote for preparing that judgment at all, whether it was division bench, full bench, or single bench. These are few points and principles, I would say, which a judge should keep in mind always. So, judgment writing, as I said, and as the theme of your this event is an art. Now, art you have to master by practicing. No judge becomes a very bright judge or very prominent judge on the first day of his career. It takes years to write good judgments. And one of the comments which came from my colleague in Rajasthan High Court when I was earlier there in 2005 to 2016, that brother, I don't want to praise you because you are my younger brother, but your judgments feel like a poem. When I start from the first sentence, I cannot end up before the end. And they are brief, but they give everything what the parties need to know about the issues. And that is what I always kept in mind, that I should not miss out a point. I should deal with all the issues. I should be fair and honest. I should not be biased. I should do my judgment in accordance with the law. I should not violate law. Now, one fine thing which the younger brethren should know from me, what a little experience I got, is the difference between a court of law and a court of justice. If somebody has already told you, you should know that. The judiciary up to the level of district court are bound by the statutory provisions and they have to work within the framework of law. That is why they are called court of law. They cannot go beyond that. They cannot go beyond evidence. Court of justice, that is the constitutional courts, High Court and Supreme Court, they are not supposed to go out of framework of law every time. But to meet the ends of justice, they can twist, they can eschew, they can mold the procedural part or some legal provisions by the process of interpretation. And that is where the difference between court of law and court of justice lies. And that is why the constitutional courts enjoy a little higher status or a little higher level as per the scheme of constitution, which is the most beautiful document given by our forefathers to our country on the democracy and the republic which we got in 1950. And we have to work in that spirit. Whether you are a civil judge at the bottom of the rung or you are a Supreme Court judge, the ultimate principles, ultimate parameters bind you everywhere. The difference is given not because of your status or because of salary difference in salaries. No. The difference is given because perhaps you will have more good sense of fairness and reasoning and judicial training to mold the cause of justice or the result of justice in such a way that even if some procedural things come in your way, you can override them. That is the fine difference. Friends, as I said, no long lectures. This was I spoke from the heart and what I felt as a judge and as a lawyer for so many years. I definitely wanted to be to share it these with my younger brothers and sisters, which I always enjoy. Whenever there is a call from some university or law school, subject to my availability, and I try to make myself available as much as possible. And whatever it is, for us people like us, and in the late 60s, now 64, 65, it's time to repay back to the society what we got from it. And therefore, whatever experience came our way in this last 40 years of judicial career, we should share with you people so that we leave this legal profession in a very, very strong kind of community. Because this profession, I'm sure, can lead from the front. And when I shifted from CA profession to law profession, I didn't even know that God will bless me with so many of opportunities to serve the cause of justice. And of course, I have all the reasons to be a contented man now in the society. And therefore, I wish all my younger brothers and sisters, and I always express a very high gratitude to the law teachers, all teachers, of course, but law teachers in particular, who are shaping the minds of the young students, young lawyers to be, and that is what their duty is, and that's what they are assigned this pious duty. And I must congratulate Madam Pandya and all other law faculty members who are listening to me for this opportunity given to me. And thank you so much. Jai Hind.
Thank you so much, sir, for such an enriching uh, and telling our students to understand how important it is to know the intricacies of judgment. Sir, if it is okay with you, can we take up two or three questions that we have received from our
Sure,
students
sure.
on the social platform?
That is the
Uh,
real reflection of whether the people have understood what I said.
Sir,
What
first
is it?
question. In span of decades of services that you have, sir, were there any particular challenges that you encountered while deliberating on a case and coming to a judgment for it?
The only challenge, nothing from the lawyers or nothing from the politicians or outside society. These challenges, even if people might have tried some occasions, I just pushed them aside. But the only challenge was how to excel upon my own thoughts, how to do better. So the first draft which I dictated on the board, there were always some additions and some in the same line. Of course, the judgment's results never changed, but how to improve upon the reasons and inputs in the judgment, that was the only challenge, and that always made me to sit and burn my midnight oils with the draft of the judgments, and I hope I could learn the legal intricacies and deliver better judgments. So that's the only challenge. Otherwise, no other challenge came. People sometimes fear that as a judge, did the people try to approach you? Did some politician try to approach you? Did somebody try to influence your judgment? Well, it all depends firstly on the honorable judge himself or herself. If you are open to these kind of things, people will come to you. People will offer you all kind of things, and then. But if you are firm and strict enough, and you are honest enough in the heart, integrity enough, then these things really do not matter, and you can always ward them off. So no challenge that way in my life.
So another question. In your experience, what are some of the most important qualities and skills for a judge to possess, specifically the new judges that are coming up on the bench in a few years or so?
Very, very good question. Firstly, my dear friends, a judge has to read and read and read. He has to be a student and studious all the times. Because reading gives you real good insights. Your thought or your mind without reading materials will not deliver as much as you can deliver. And secondly, judges have to maintain a typical kind of aloofness from the society and legal fraternity. That is very necessary. The party culture, which of late has developed, I would say, and which is very inviting for the judges also. Not that they should cut off from the society, but there is a limit to mix up with the society also, because there the people have opportunity to come closer to you beyond sometimes the limit of the respect or the aloofness which a judge should maintain. And that is what in the code of conduct for the judges evolved by the Supreme Court in 1997. And one of the papers which I delivered in Europe in IATJ forum, social networking in judges. We agreed that you can be on Twitter and WhatsApp, but then what you will write, what you will not write, you have to decide. You firstly cannot deal with an issue or a point which you are dealing with as a judge in the court, in the social platform. And you cannot take inputs on a social platforms to your desk and then deliver the judgment based on those WhatsApp university material. No, you cannot do that. You are bound by the material on the file, the arguments raised, written or oral. Then your thought process should apply to that. Your legal knowledge should apply to that. So it's a very tough job, but it's not impossible also. You can do that. It all depends upon your personal character. Yes, ma'am. Mayuri ji.
Sir, I have one question.
Surely.
If you allow me.
Coming from you will make my job difficult, but I'll try.
No, no, not at all, sir.
Please.
Sir, during your career as a judge, uh, your any dilemma to you for writing a particular judgment? Can you share with us any incident
Dilemma,
that
you
that
means
gave you some dilemma or any memorable judgment writing?
memorable, there are many. But dilemma, whether I should allow or dismiss, grant this relief or not, never came. Never came. I mean, one instance I would tell you, I was talking about the corrector and the other people trying to interfere kind of thing. I'll tell you one instance. Not that people do not try to approach judges, they try. That is where your test is. In my early career, one central union minister called my private secretary and he told that I want to speak to judge. The private secretary was already instructed not to allow any such calls beyond the call of the legal profession or my job. But he said, sir, a union cabinet minister wants to speak to you. He says it is in courtesy call. So would you like to speak? I somehow thought and then said, all right, let me say if it is courtesy, then why not? Then the moment he said hello, he said, जज साहब नमस्ते नमस्ते ठीक है क्या है बताइए सर आपके सामने आज एक केस these were the words he could speak. I said, Mr. Honorable Minister, please stop here. I am a High Court judge. You know that. You are talking to a High Court judge. And if you are going to talk to me something about a case which is before me in the court, I may tell you, I feel very offended. And if I record your telephone call in my court order today, nothing will happen to my judgeship. You will lose your ministry by the evening. And therefore, please stop in your tracks. Don't think that every person is approachable like this. And you are trying to behave as if you can dictate something to a high court judge. I'm sorry, you can never do that even to my civil judge. If you do that, I'll punish you for that. Leave us aside. If you have a case, send your lawyer. He will argue in front of us and we will deal with this. So this is where the first point of your character shown to the people at large is number one. Number two, I never met a lawyer at my residence, government residence, when I was sitting judge. Even if they had to invite me for a marriage of their son and daughter, they could only come to my chamber. My staff members would remain there with me, one or two. They could give the card, take my greetings. I will always send a congratulation letter. If time permits and other judges are going, not going, we will go. Otherwise, nothing beyond that. So these are certain points, aloofness as I talk. The judges, right from civil judge level to Supreme Court judges, we do try to maintain. So this is what it is all about. Dilemma in deciding what should I do or not do, fortunately or unfortunately, never happened. I knew what is going to be the result when the arguments were getting over. And that is why I could dictate the judgments, 90% of my judgments on board after conclusion of the. And I do not claim any distinction in it. I know most of my colleague, brother and sister judges were more intelligent, more sharp than me. They were more learned also. So these were the few tips which our seniors, when we joined the bench, gave us. And we followed it. Yes.
Thank
Any
you
other
so
question?
much. That's it, sir. Thank you so much, sir, for sharing your expert view and expertise with the participants and the audience who have joined us. I'm sure today's lecture would have enriched them with the understanding of how and in what way the judgment needs to be written and understood. This would help the students in longer run in their career, especially those who are interested to pursue judiciary. Thank you, sir. Sir, I would now request you to please announce the runner-ups and winner for National Virtual Judgment Writing Competition 2024. Sir.
Thank you. Thank you. Yes, I have the result with me, dear friends, and you must hold your breath now because, and as I earlier said, winning or losing is secondary importance. But yes, it is time to rejoice or time to say better luck next time and I'll try better next time, things like that. So this is the result, and I'll announce it in reverse order. Runners up first, and then winners second. I think you approve of that course of action. Uh, Second runner up, NJWC4 is Maharashtra National Law University, Aurangabad. So clappings for them. Congratulations to you, dear friends. And now comes the second stage. First runner up. First runner of this competition is School of Legal Studies, CUSAT, Ernakulam. Congratulations. Very good clapping on the screen. Thank you. And now it comes time to announce the winner. And the winner is Christ University, Levasa, Pune. If these winners, you could hear the result, or I was in mute.
No, sir. We were properly audible to us. The participants are watching this live session through YouTube, sir. So they
YouTube,
can
so they
hear.
cannot respond. They cannot
No,
respond.
they can hear us, but they couldn't respond.
Okay,
They
okay.
can respondents through the responses through the YouTube chat.
Email later on, email later on. So we
Please,
have the
please.
4 participants. I tried to see the present members, but that was not showing any number of members in the meeting. So, anyways,
Yes.
so once again, thank you and congratulations, all dear friends, and congratulations to the winners. And better luck next time to the runners up. You have not done less than what the winners did, but it is just a matter of degree or matter of chance that the team Christ University won this competition. And once again, congratulations to them. And yes, a great thanks to the JLS Gujarat, Ahmedabad, and Madam Pandya, Madam Matarani, and Madam Nehaji to have invited me for this beautiful event. And thank you so much once again. God bless you.
Now, I would like to invite Dr. Jia Matrani, Assistant Professor, Faculty of Law, GLS University, and the Coordinator for the National Virtual Judgment Writing Competition 2024 for her official vote of thanks. Over to you, ma'am.
Thank you, Neha. Respected Honorable Dr. Justice Vineet Kothari, sir. Respected Dean Madam of Faculty of Law, Dr. Mayuri Pandya, ma'am. All the participants, viewers of this judgment writing session and the result declaration ceremony of 2024. It is my privilege and honor to extend a vote of thanks on behalf of Faculty of Law, GLS University. We have just witnessed a very enlightening and thought-provoking session on art of judgment writing by Honorable Dr. Justice Vineet Kothari, sir, who already has decided and delivered more than 50,000 cases, but then also Lordship considered himself as a student of law. I would like to express my profound gratitude to Honorable Mr. Dr. Justice Vineet Kothari, sir. Sir, thank you so very much for sharing real-time examples, the words, the languages, the maxims, the terms that judges used to use for delivering the judgment. This will surely would have helped all the participants and the students who wishes to pursue their career in judiciary. We have been fortunate enough to be backboned by Dr. Mayuri Pandya, Dean Faculty of Law, GLS University. I extend my heartfelt gratitude to you, ma'am, for always being there and for your immense support and guidance throughout all the events we have under the banner of Faculty of Law, ma'am. Many thanks to participants of the competition. I extend my congratulations to all of you. You have submitted a wonderful judgments, but always we always it is the winners and the runners up. We are extending a congratulations and warm thanks to participate in this judgment. It is your enthusiasm for the competition that always helped us to serve better and the best. I would like to thank the entire Faculty of Law family, teaching and non-teaching staff for their support, dedication, teamwork, and untiring efforts for the competition. Thank you to all the viewers of this session and the result declaration ceremony of National Judgment Writing Competition. Thank you once again. Thank you for being with us. Thank you.
Thank you.
Thank you, sir.
Thank you. Okay, ma'am.